So today we'll be beginning with schedules. I had informed you that we'll be starting with this topic, and first what we'll do is we'll go through all the schedules that are there in the Constitution, right from the 1st to the 12th, what they signify, what are they about, and after that we'll be discussing 5th and the 6th schedule related to tribal areas and the scheduled areas. Yes? Favorite topic? Okay. Without looking at this slide in front of you, just tell me this first. How is India defined in the Constitution?
India, that is Bharat, shall be a union of states and union territories.
Union of states and union territories. Is it written there? India, that is Bharat, shall be a union of states. Okay. Does that ring some bells when we talked about, I mean, not with me, you didn't, but when we talked about the features of the Constitution, we said India is a quasi-federal system. We have a quasi-federal system? Yes. So there also we mentioned this line written here. India, that is Bharat, shall be a union of states. So we told that, okay, there is a tilt towards the unitary factor. But since states are also talked about, there is a federal character as well. Okay, states, of course, we know there are 28 states, union territories 8. Do we need to name these? I think we all know. Yes. Do we also know how new states are added to the Indian Union and how the names of the states are changed, how the territories of the state can be changed? How, I'm asking. That's what. Again, how? What's the process? Amendment? Okay, let me put it like this. If we need to change, say, the territory of a state, add new territories, or say change the name of a state, do we need to make a constitutional amendment under Article 368? We have a no? No. It doesn't? Then how do we change it? So, how? What's the amendment that we do? How do we do it? That's what I'm asking. You're telling me what do we do? That's the process again. We make a law. The parliament makes a law saying that we are making such and such changes, whatever the changes might be. We'll talk about what kind of changes we can make. And if that law, if that act of the parliament has an effect of changing the wording of the constitution anywhere, say in the 4th schedule or in the 1st schedule, still that will not be considered a constitutional amendment under Article 368. But such a bill, when it has to be introduced in the Lok Sabha or the Rajya Sabha, can it be introduced in either house? Can a bill for making such an amendment be introduced? We have a yes. It has to be introduced in the Rajya Sabha. Anybody for Lok Sabha?
Either house. Either house.
Yeah, that we have. All in favor of either house. 1, 2. All in favor of Rajya Sabha. 1, 2, 3. All in favor of Lok Sabha. These people have decided we will not raise hand for anything, so that later it doesn't come to us, why did we say it? Yeah, so I asked that first, no? Okay, let's go through the constitutional language, how constitution puts it, and let's see if it makes clear to us, and if it doesn't, we'll still explain it, yes? Okay. The territory of India shall comprise of, that we already talked about, there are territories of the states, there are the union territories, and the territories that may be acquired. New territories also can be added to the Indian Union. Parliament may by law That's what I was asking you. How do we admit it? So Parliament by law may admit into the union or establish new states within the area that we have. Within that also we can establish new states. How? Parliament may by law form a new state by separation of territory from any state. So one state is like Andhra Pradesh was divided into Andhra Pradesh and Telangana. So a part of Andhra Pradesh was separated from, that's the first thing, separation of territory. By uniting two or more states, that can also be done. Has it ever been done?
No.
It hasn't been, but that can be done. So maybe today we mostly consider the linguistic part to be the forerunner as to when we decide on the basis of what do we reorganize our states. Linguistic reason is considered to be the, the top reason. Although there are other reasons also. We say it should be administratively efficient, the size should not be too big, not too small. All those things are there. Okay, next. Uniting any territory to a part of a state. What does this mean? Uniting any territory to a part of a state.
If there is any outside part that can be united into the India.
Yes, that can be done. A union territory can also be merged into a state. That can be. What does the second thing say? Increase the area of any state. By any of these methods we can increase the area. Diminish the area of any state. How can we diminish the area? By dividing the state, one, and second, giving away some part of that state to maybe a union territory or to another state. Yes, that's how we can diminish. Alter the boundaries of any state. Maybe the area stays same, but now the boundary lines change. That also we can do, the parliament. All these things can be done just by a law. Alter the name of any state. But there is a thing, there is a proviso for this. No bill for their purposes shall be introduced in either house of the parliament. So the either house guys win. It can be introduced in either house of the parliament. Lok Sabha also, Rajya Sabha also. Yes, except what? Recommendation of the president. So what other bills are there which require the prior recommendation of the president? Money bill. Financial bill 1.
To constitute a delimitation commission.
Delimitation commission. What else? How about a constitutional amendment bill? Sure?
Yes, sir.
Good. Okay. Where the proposal affects the area, boundaries or name of any of the existing states. So if you're changing the name of any state, boundaries of any states or the area of any states, then such a bill has also to be referred to the states that are being affected. But is the view of the states binding on the center?
No.
No such reference has been made in the constitution. But how much time is given to the states to act on that, on the bill that has been sent to it? How much time do they have? What is mentioned then? Can we, that way will not be ever able to change the name, no? Because we have to wait to get their recommendations. Yes or no, we agree or not, but we have to wait. So how long do we wait? For such period as the president may specify. So when the president sends those bills to the states affected, he gives them time, say 1 month, 2 months, 3 months, whatever the time president signifies, asking them to respond within that period of time. And when they respond, they may either act on it or not act on it. If they not respond, they can still go ahead. Yes? Okay, that's how things can be changed.
Will this alter the principle of federalism?
Okay, that's a debatable question.
That means if we consider Telangana and Maharashtra, there is a border dispute that the people who speak Marathi were bordered with the Telangana.
Yeah.
If,
That also exists with Karnataka also, yes.
Yes, sir, same with Karnataka. If the referendum from the people have to be taken in which state they want to include it.
We are not creating a new country here. Referendum is for giving autonomy, maybe for creating a separate nation, or a completely autonomous territory like we have the Catalonia in Spain, or we have that kind of situation going on in the US, the states have complete autonomy, or
so if Telangana and Maharashtra, if people from either state included, the separation feeling will be arised, and eventually sometimes discontent will be.
Yes, that's there, but the point stays. So you see, that's a discussion for the reorganization part. But since you asked, where do we stop? Where do we draw the line that now that's enough? Because as diverse as India is, we cannot go on making divisions. So now, for instance, Andhra Pradesh and Telangana speak the same language, but we still divided it.
There was not any conflict with linguistic factors, sir. Although linguistic factor major partly divided the state, but the border dispute was not arose after the division. But if we consider any other states with division of Maratha, Telugu, or else Kannada, Telugu, there will be any distinguished factor causing around any violence. So, taking consent of state is rather recommended without binding factors. How it is possible?
See, why we seek the opinion of the state is to see what they want to say. Maybe there is something that escaped the eye of the parliament, right? We want to know what the state wants to say on it. Is it so important to that state that they don't want to give away that region? Maybe there is some other region they are willing to give away. Maybe the center is thinking on the lines of administrative efficiency. They just want to change the area, and to them it doesn't matter as to which area they give away or which area goes away. That's why we need their opinion. Not like they should tell the center as to you, please take this away from us and give that away. In that case, we would have added a provision saying that the legislative assembly, like we say in the case of councils, creation of councils, that the legislative assembly has to pass a resolution asking the parliament to change the area. But that's not so. The parliament does it first, the president sends the bill to the, just to get their opinion. It's the other way around. And like, of course, you already have discussed this, that we are a unit, at least we have a tilt towards unitary features, if not a completely unitary system. Our states do not have a right to secession. The states in the United States have that right. We do not. Different systems, right? Okay. Any law, it may lead to the changing of the language of the first schedule and the fourth schedule. What's the first schedule? What's the first schedule? That's what we're discussing here. A list of states that are there and a list of union territories that are there in the that constitutes India. That's what the first schedule is. So if we have to change the name, we'll have to change the name in first schedule also. If we have to change the boundary or create a new state, we'll again have to change. But that change that has been brought in that schedule, Schedule 1 and Schedule 4. Schedule 4, what's Schedule 4? Allocation of seats in Rajya Sabha. That will also change because area is now changing, population is changing, seat allocation will also change. So we did make changes to the constitution, but not through the process mentioned in Article 368. We just need to create a law. Our parliament just passes an act saying that now such and such changes have been made. Yes? So two things to remember here. One, we do require the prior recommendation of the president, but that won't be considered a amendment under Article 368. Yes? Okay. However, it's just the reverse in Article 368. There we are using Article 368, but we don't require the prior recommendation of the president. Yes? Can we move ahead? Second schedule. What's the second schedule about? Of? What is the president's current salary?
5 lakhs.
Who decides the president's salary? Parliament by law. Who decides the governor's salary?
Parliament.
Then what's the state doing? Okay, where is the president's salary paid from? President's salary. And where is the governor's salary paid from? Consolidated fund of the state. Do you see a contradiction here also that we mentioned in the case of Central Information Commission?
Yes, sir.
That the center is determining how much amount to pay to the governor, but that amount is coming out of the consolidated fund of the state. So the central government is kind of determining how much money we will take from the states, or how much money the governor will take from the states. A conflict, a federal conflict that exists there. Yes? Remember in the case of Central Information Commission also we mentioned this, that a change has been made in the salaries of the information commissioners according to the new that RTI Amendment Act 2019. The central government will now decide the salaries. Earlier the parliament had to decide, but the central government not just decides, the executive decides, and the state has to bear the expenses. Here also the same case. Okay. This I just wrote this down for you so that you remember whose salaries are mentioned and whose salaries are not mentioned in the second schedule. If ever a question comes about that, however, this is very factual and we shouldn't expect any question out of here, but UPSC doesn't go by expectations, right? So President, Governor, Speaker and Deputy Speaker of Lok Sabha, Chairman and Deputy Chairman of Rajya Sabha, Speaker and Deputy Speaker of State Legislative Assembly, and the Chairman and Deputy Chairman of State Legislative Council. So how many people now? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 till now. Then there is salary, allowances, leave of absence, pension of Supreme Court judges. How many there might be? Item number 1. So it's 11 items now. Salary and allowances of the judges of the High Court. This I specifically use this full statement as it has been, as the details have been given in the second schedule here. For the Supreme Court judges, pension is also mentioned, leave of absence is also mentioned here, but for the High Court judges, only the salary and allowances are mentioned. That's the difference. So where do they get their pension from? Actually, who determines their pension then? Parliament by law. We discussed that when we discussed judiciary. Parliament by law decides that. Not mentioned here, although. These salaries have been mentioned as in comparison to the courts that existed before our constitution came into existence. Sleepy? Before our constitution came into existence, what court did we had? What was the highest court in India? The federal court. There was one more court which acted as British Privy Council.
Yes, sir. Not in India.
Which acted as the highest court of appeal.
Yes, sir.
That authority was also transferred to whom?
Federal court.
Supreme Court. It was transferred to the Supreme Court. So that's the Supreme Court. That's all that we talk about here in this schedule. It's a detailed provisions that his salary will be equivalent to the judge of that court, and so on and so forth. Okay, last we have Comptroller and Auditor General of India. So +1. This is High Court, Supreme Court, CAG, and 10, 12, 11, 12, 13. 13 categories of salaries are being discussed in Schedule 2. Yes? Okay. We move on to the third schedule. What's the third schedule about?
Forms of oath and affirmation.
Forms of oath and affirmation. Have you any time gone through the language of the oaths? Yes or no? Is there any other oath in the Constitution that's not written here? President. How about the Vice President? Vice President's oath? Is it mentioned in the third schedule? Is it mentioned in the Constitution? Huh?
As a member of MP in Rajya Sabha,
Is the Vice President a member of Rajya Sabha?
No, chairman of Rajya Sabha.
He is the chairman of Rajya Sabha, but does he take oath as the chairman of Rajya Sabha or he takes oath as the Vice President?
Vice President.
So where is his oath? His oath is also there in the main language of the Constitution, just like President's oath. But other oaths are right here in front of you. For the sake of simplicity, I have noted down the keywords that exist in most of the oaths that are there, and a little difference wherever it lies. First, oath of office for a minister for the union. So it could be any kind of minister, right? Any council of minister, deputy minister, cabinet minister, minister of state, whatever minister is. If it's in the council of ministers of the center, this is the oath they take. They take an oath to bear true faith and allegiance to the Constitution of India and to uphold the sovereignty and integrity of India. This is oath of office when they are entering into the office of that minister. Every minister, both at the state level, also at the central level, they take two oaths. One, office, and the oath of secrecy. I have not written down the language for that here because it just says that whatever comes to my notice, I will not share that to anyone unless I am required by law to do so. That's what secrecy basically, that I will not tell anything in my official capacity out of the bounds. Yeah? Third, 3A basically, oath and affirmation to be made by a candidate for election to parliament. Remember when we were discussing the parliament, I told you that every person from getting into the process of being elected to reaching and taking participate in the proceedings of the house, he has to take two oaths. One, when he fills out the nomination, when he puts himself out as a candidate, that's this oath, oath of affirmation to be made by a candidate for election to parliament. And then when he actually starts taking part in the proceedings, when he goes sit in the house, who gives him that oath? This oath is given by the returning officer, RO. When he files his nomination, he has to take that oath before the RO, returning officer. This oath and affirmation to be made by member of parliament, that is when he goes sit and takes part in the proceedings in the parliament, who gives him the oath?
President or else any person recommended by President.
Yes, excellent. President or any person nominated by the President. We have done this, already discussed this. Okay, next oaths, judges of the, okay, these the language of the oath of affirmation by candidate as well as a member of parliament, it's the same, it also says the same thing, faith and allegiance to the Constitution of India and uphold the sovereignty and integrity of India. Next we have oath and affirmation to be made by judges of the Supreme Court and the Comptroller and Auditor General of India. So the judges of the Supreme Court and the CAG take the same oath. Apart from this, they also take this oath, faith and allegiance to the Constitution of India and uphold the sovereignty and integrity of India. They take one more oath along with this, an extra line is added which says that they will uphold the Constitution and the laws. Uphold the Constitution and the laws. That's only in their oath. Also, in one more category, that's High Court, that which is exactly the same as this one, which I have written also as 4. That's according to the, but it's High Court judges, this is Supreme Court judges and the CAG. What other oaths are there? Oath of minister for a state, council of minister in the state level. Then it's the same, this same oath that the minister at the union level takes, it's the same oath. 6, oath of secrecy for a minister at the state level. So at the state level also the minister takes two oaths, oath for office and oath for secrecy. Then we have 7A, a person who is putting himself out as a candidate for election to the member of Legislative Assembly or Legislative Council also. He has to take this, and then when he actually goes on and becomes a member, sits in the house, he has to take another oath. The language stays the same. So in other all cases, the language is this: faith and allegiance to the Constitution of India, uphold the sovereignty and integrity of India. In the case of Supreme Court judges, CAG and High Court judges, there is an additional thing added, which is uphold the Constitution and the laws. Yes? Makes sense, no? That's all you need to remember about this.
Oaths made by the member of parliament or members of MP or MLA, sir. When the MP should make 3 oaths, no, sir?
2 oaths.
Oath of office, secrecy and...
That's minister.
Ministers. So, ministers, means when they will take this oath, sir?
When they will take this oath means?
Like...
Yes, yes.
In which occasion they will take, means when they started in the Lok Sabha, they will take, sir, or else they will have separate?
No, they take oath before whom? Who gives them the oath? So does the president sit in the Lok Sabha, Rajya Sabha?
No, sir.
So of course they will not take an oath inside the Lok Sabha and Rajya Sabha. And is it mandatory to take this oath first? Oath or affirmation to be made by a member of parliament?
Yes, sir.
Is it mandatory to take this oath first before taking oath as a minister? Can a person who is not a minister become a person who is not a member of parliament become a minister?
Yes, sir.
Then he doesn't need to take this oath, no? It's not compulsory to take the oath for being a member of the parliament before becoming a minister, because we still have 6 months, right? And he will only take an oath to member of parliament when he actually becomes a member of the parliament.
Not necessary after parliament, they can be taken before also.
Of course, why will he take the oath of member of the parliament when he is not a member of the parliament? But he is still a minister. When he goes on and becomes a member, he takes that oath also.
Sir, why only the oaths for only candidates selecting for parliament or else MP, sir? Not why not for president, sir? Like,
So he already there.
no, sir. Who are participating for president election, they should also.
No, they don't take an oath. This was added later by an amendment here. That's why it's 3A and 7A. In the case of president, there are very few runners, and this oath was basically added to, prevent unscrupulous cases, which we call it, under the Representation of People Act, and then we had that criminal background thing. And in the case of president, that thing is said to be taken. It's a given that if there are 3 people, we know where they stand. In the case of members of parliament, there is thousands of people who are participating all across the country. It's not possible to check everybody's background and all those stuff. Do you know this? When a person is appointed to be a judge of the Supreme Court or to be a judge of the High Court, they have to go through a background check,
Yes, sir.
which is done by the Intelligence Bureau. The central government conducts that background check before appointing them. Have you seen this series that came on Netflix recently, Spy?
Netflix.
Yeah, good thing, no subscription. So actually, why I made a reference to that now, in that series, there is this guy who belongs to the Israeli, what's they call, Mossad, right? And he goes on and becomes a part of the Syrian government. He basically goes on and becomes a minister there. And he had that kind of, all setup created that nobody knew that he could be agent. So maybe to avoid those kinds of things, we have this whole process of background checks. In the US, it's called vetting. Every person, maybe who becomes a president, vice president, minister, secretaries, all have to go through a process of vetting. In fact, everybody who works in the White House has to go through a process of vetting. In India also, whoever works in the PMO, in the president's office, they have to go through a process of background checks. That's just to, understandable. Why would we would need to do that? Yes.
A minister may not be with a member of parliament. Sir. He takes oath as a oath of secrecy. By virtue, Constitution gave that anybody, if a member is minister, he can participate in either of the house proceedings.
Mm.
Since because of he is a minister, can he participate in the proceedings, sir, without taking any vote?
For taking part in the proceedings, you don't need to take a oath. It's for the voting process when it comes. So he can, of course, by virtue of being a minister, but by virtue of being a minister, he doesn't get the vote. No, he gets a vote by virtue of being a member. So he won't be able to vote. Yes, he can participate.
Likewise, if recently in West Bengal, since Mamata Banerjee have lost in her constituency, she can become chief minister.
Yeah.
And she can participate in the proceedings without
Yes. Vote. Yes. That's authorized by the constitution itself, as written, that a minister has a right to audience before both the houses, so that he or she can. Yeah. So oaths done. Fourth schedule, allocation of seats in the Council of States or Rajya Sabha. Not much to discuss there. Just every state, against it a number is mentioned. This state has this much, this state has this much.
Why president schedule given the constitution, mentioned in constitution, sir?
Important post, the highest constitutional post and the second highest constitutional post.
Why one people schedule? No other specific reason, only for.
Yeah, that's the only reason. That's the only reason, because that's a very high constitutional post. So we make it part of the mainstream constitution. Okay. Yeah. Fifth schedule. What's fifth schedule? You can read it, right? Scheduled areas and scheduled tribes, except the states of sixth schedule, which are Assam, Meghalaya, Tripura and Mizoram. Next we have seventh. This we are going to discuss in detail today, so we'll skip through it. Seventh schedule, I already gave you the exact number. Originally there were 97 subjects. 3 new subjects were added, but item number 33 and item number 92 have been deleted. So the actual number today stands at 98. In the state list, there are 66 subjects originally. Item number 11, 19, 20, 29, 36, 52, 56, 55 and deleted. So the actual number today stands at 59. So 7 subjects have been deleted. In the list 3, 47 originally, 5 new have been added. These are the new ones that have been added, and the actual number today stands at 52. Yes? So if you take a preliminary look at the list, it will still seem that it is still 97, because when an amendment is done, they add it like A, B, C. They don't actually go beyond those numbers. So 395, we stick to 395 originally, but we keep adding A, B to those names, like we just see here. 11A, 17A, 17B, 20A, 33, like that. Yes, shall we move ahead? 8th schedule. What's the 8th schedule about? What? Recognized languages. Official languages. Scheduled languages. Official language is a very different term, and recognized language is also a very different term. We have thousands of recognized languages in India. So how many 8th schedule languages are there? How many times amendments have been made to these languages? 3 times. 3 amendments have been made. Originally there was 14 items, now there are 22. Once 4 were added, once 1 was added, 3 were added. The latest amendment was in 2003, by which Bodo, Dogri, Maithili and Santhali were added in the same order. However, when you open this 8th schedule in the constitution, there are numerous brackets that are there. Yes, almost every language that's there, it has a bracket, double, triple brackets are there. That does not mean that they also have been added by amendment, but what actually happened is, these languages are ordered alphabetically, and whenever new languages are added, the order has to be changed. So that order also requires an amendment. That's why they are kept in brackets again. Yes?
On what majority will be amended?
By Majority by law, parliament by law, they can add a language to the constitution.
So if demands to insert its language in a schedule of each schedule, Parliament just by law it can add.
Yeah.
That means by amending the constitution.
Not Article 368 amendment.
Simple majority.
Simple majority. Parliament by law.
On what criteria these languages are?
There are, but I have a different discussion on the 8th schedule altogether, because if we get into the details here, then you'll also ask why only 22? What special do they get? But that's a complete discussion that we'll have on 8th schedule also. You just remember this. Although there is one more thing that I wanted to ask you here. It skipped my mind now. Yeah. So is there something, somewhere you can find many of these languages written right in front of you?
You said the recent amendment is in 2003, but here it is mentioned 2011.
What's that?
For Oriya, they have changed to Oriya.
Wait,
It's
how many?
Amendment Acts, only one.
How many languages are there then? Name was changed.
That doesn't come.
That doesn't come. So these languages are still same. The last amendment to add a language was in 2003. Languages stay the same. We didn't change the language. Okay, anyways. I was asking where you can find it written right in front of you at almost any point of time. Where can you find many of these languages written right in front of you at almost any point of time? Currency notes. How many languages are there on the currency notes?
15.
16, 14 or 16.
Any other guesses?
14.
Let's check it out.
First 14.
Yeah, let's check it out.
15, sir.
Huh? 15 languages. Which note do you have?
15.
Yes.
I have counted.
Okay. Yeah. Which languages are these then?
Urdu, Telugu, Tamil, Gujarati.
We have a polyglot.
Odia, Malayalam.
No.
20 languages.
Huh?
50 languages will be in 22 languages.
Why didn't they put in 22 languages? They couldn't fit it there?
Yes, sir. Space problem.
And how did they choose it? Which languages to fit in the note?
No.
I don't know, I'm asking. Okay, to give you an idea, I googled it for you. First language is Assamese, then we have Bengali, Gujarati, Kannada, Kashmiri, Konkani, Malayalam, Marathi, Nepali, Odia, Punjabi, Sanskrit, Tamil, Telugu and Urdu. Interestingly, Nepali is also there. Is Nepali a 22nd schedule language?
Yes, sir. Yes, sir.
You have write it in front of you.
Checking, sir. What?
That's one reason though, most widely spoken. But Nepali? Bihar? Hmm? Our currency is allowed in Nepal, yes, that's there.
So it is because these languages are having their own alphabets.
So Kashmiri and Urdu use the same alphabets, so then so that argument fails, no? Even if we find one exception, that argument fails.
Significance is there, they might include, sir.
Urdu and Kashmiri both are not very ancient languages. Again, that argument fails.
Since they are considered as minority, they are not
So that's why they added.
to give that equality.
That they could have added in the 22 schedules, in these 22 languages. That could be reason there. Why on the note?
Uniformity.
That is where there is very small section of people who will speak Kashmiri, no?
Uniformity, sir. We are not out of India. We are all one.
Sir, you know
So the people who are speaking languages other than these 10 languages, they're out of India? Okay, this is just to ignite that thing in your mind, that why is it like this? So that you go home and search. I have the answers, but we'll again discuss it when we, no. Then what's the whole purpose of me putting this in your mind that go and look at home? Then I will just, I'll just tell you the answer and it goes away.
Sir,
Okay,
on
yeah.
this alphabetic order, sir.
This.
On the note, sir.
Oh yeah, they're also alphabetic. So it ends with Urdu, so I guess it must be alphabetic only. Okay. Ninth schedule. What's the ninth schedule?
Parliament inserts in this schedule that cannot be questioned in the court of law. Before, after judicial review, that is.
Scrutiny.
Parliament any law added before April 24.
Let me write down all your arguments. So I hear land reform, something related to land reforms.
After judicial the Bharti case, which are come under judicial review, sir. Cases of
Laws that are put under this schedule cannot be scrutinized for judicial review.
So no judicial review.
After
After 1973.
We moved after 1973. What else? Yes. State can what? No, tell me. Maybe it's correct. Maybe it's not. So what? That's how we began, at least. Yes, property, land-related things.
any state acts, any acts passed.
You said Parliament first. Now it's state.
I did put a parliament in it, sir.
You read it.
Yes, sir.
Parliament Acts plus State Acts. So the states can also place
Act under schedule.
an act under Schedule 9. Interesting thing. Is there anything else states can change in the Constitution?
No, sir.
Then how come they can change this? They're adding something to the Constitution, right? There are 284 laws that are there in the, and most of these come from the states and the 9th schedule, yes.
9th schedule came after the constitution amendments, sir. This is not given by the forefathers.
So first amendment itself we inserted the 9th schedule. So just 1 year after, same year basically. Yeah, 1 year after,
Maybe,
1951, yeah.
This may not dilute the very purpose of the constitution provision, so that's why state were given. The very purpose of the constitution is to be uniformity, and the powers more was vested with the union. If 9th schedule hampers any of the power of constitution, they cannot be include the state here. Since they will not violate the constitution, so the state is given permission. Maybe.
Maybe the law they are making itself violative of the Constitution?
That can be, since a governor is there, that cannot be done. No, sir. A state will have to be taken assent by the governor. No, sir.
Yes.
If
So what will he do?
He can stop the bill or forward it to the president.
Anything that states want to add to this schedule have to be sent for the assent of the president. It's only with the assent of the president that you can do this. You can add, states can add, but it has to be sent for the assent of the president. So the governor has to reserve such a bill for assent of the president, only then it's added. So it's not entirely the state, the center also gets involved in the whole process. Yes? Any burning issue that you remember related to this 9th schedule? Not very recent, but it's still going on. So here, let me just clarify these things that you said. Land reforms, these were the originally how we came to create this 9th schedule, because we wanted to add some laws related to land reforms which were basically violating fundamental rights. So we added 9th schedule saying that the laws that have been inserted in 9th schedule, even if they are violative of fundamental rights, they will continue to be in force and they will not be subject to judicial review also. We'll read it out what it says and then then next, no judicial review, we'll talk about that. Property, Land, Parliament Act and State Act as well. Yes, somebody read this out. Without prejudice.
Without prejudice to the general.
And this is Article 31B, by the way, that we are reading now. Yeah.
Without prejudice to the generality of the provisions contained in the Article 31A, none of the acts and regulations specified in the 9th schedule nor any of the provisions thereof shall be deemed to be void or ever to be become void on the ground that such act, regulation or provisions is inconsistent with or take away or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree or order of any court or tribunal to the contrary. Each of the said acts and regulations shall, subject to the power of any contempt legislative to appeal or amend it, continue in force.
We are not saying that these laws cannot be challenged on the violation of the constitutional provisions. We are just saying that these laws cannot be challenged on the basis that these are violating the fundamental rights only, because it says only this part, provisions of this part. This part is part 3. Only part 3 provisions, if it's creating changes there, if it's taking away any of your fundamental rights, then it cannot be challenged if it's put in the 9th schedule. That's what this article is saying. Plus added that even if there is a judgment, decree or there is an order of any court against it, then also it continues to be in force. But one of you now just mentioned something related to the Keshavananda Bharati case. What did the Keshavananda Bharati case do to this?
Because the judicial review is a basic structure and it cannot be.
Yes, that's there. Did it talk anything about schedule 9th schedule?
Not at that case.
Then which case? Shankari Prasad was before Keshavananda Bharati.
Reservation's case.
IR Coelho case, 2007. They also gave reference of Keshavananda Bharati case only, and what they said is, let's go to that. First, in the Shankari Prasad versus Union of India, the constitutional validity of 9th schedule was upheld, also 31B, and that they were not subject to judicial review. This was the Shankari Prasad case. Comes IR Coelho versus State of Tamil Nadu in 2007. I'll explain to you what this case is, but let's go through this, what it means, and I'll discuss the case also. 9th schedule, it says, is partially open to judicial review. Partially. How partially? It is subject to judicial review to the extent that it comes under the purview of basic structure doctrine. Are all the fundamental rights covered under basic structure? Are all the fundamental rights covered under basic structure? They are not. So if they are violating those fundamental rights which come under the basic structure, then it's still subject to judicial review. In case of other violation of other fundamental rights which are not a part of basic structure, it can still remain immune to judicial review. Yes, so if a question ever comes, has the 9th schedule become irrelevant because it's subject to judicial review? No, it has not. Because you can still add laws to it and they will still be immune to court's interference, judicial review, if they are not affecting one such fundamental right which is covered under basic structure doctrine. One more thing, it said that since the doctrine of basic structure emerged only in 1973, the laws that have been put into 9th schedule before this date of 24th April 1973 cannot be challenged on the basis of violation of basic structure, because at that time there was no basic structure. But anything that has been added after this date of 24th April 1973 is still questionable and brought to judicial review if it violates any of the basic structure provisions. And this question was this judgment was specifically asked in a question in UPSC by name. In Iyer Coelho case, such and such, there was a question like this. Yes.
Sir, before case of 24 April 1973, no fundamental right basis, we cannot file a judicial review.
If those laws which were added before this date, even if they violated any of your fundamental rights, even if now they are part of basic structure, that's done.
After that, any violate the fundamental rights under the basic structure, then
We can still conduct judicial review.
Sir, doctrine of basic structure is came under just judgment.
Just?
Based on judgment, sir.
Yes.
So no constitutional validity. Sir, means at that time only they determined which comes under the basic structure of the constitution, right?
Who determined?
At that time only, no, sir. Like after this judgment only they determined which constitution provisions come under the basic structure of doctrine of basic structure.
Oh, that was determined in 1973 onwards, and it was not one judgment. Various judgments keep coming and they keep adding one or the other fundamental right or one or the other provisions of the constitution in the basic structure. It's a dynamic list. As and when a constitution bench sits, if they give such judgment that we need to add one more, they do it. So it's a dynamic list. You might have seen a list given in Lakshmikant, saying that these are part of the basic structure, but that's not a static list. Tomorrow, Supreme Court can give another judgment saying that one more provision has been added, so on and so forth. So like we say that right to privacy is now a fundamental right, but it was not written there in the constitution. It's just because of a judgment of the Supreme Court. So it keeps changing, right? Yes, something else? Okay. Yeah, we're done with this. What this case is actually is related to Tamil Nadu's reservation in 1990. Presently, Tamil Nadu's reservation quota stands at 69%. In 1992, Indira Sani case,
50% cap.
they had said that there is a 50% cap. In 1990, they had already increased this to 69%. When this judgment came, it became subject to judicial review. It became questionable now that how come you have a reservation policy which goes beyond what has been dictated by a Supreme Court judgment. What they did is they passed this bill in 1993, sent it for the presidential assent, and they rallied with the central government at that time. They kind of sought help from the central government to get the assent of the president. It got presidential assent and it was added to the 9th schedule. As soon as it got the presidential assent. At the same time, when it got added to the 9th schedule, it was challenged in the court again, that whether it's subject to judicial review now or not. That judgment came in 2007. This is the Iyer Coelho versus State of Tamil Nadu 2007 judgment, which they said that partially it is subject to judicial review, but the final judgment has still not come. This matter is still prejudice. So we'll maybe have to wait.
So now they're following 69% reservation. No, Tamil Nadu is following.
They are following 69% because it's there in the 9th schedule. The court has not given any temporary or preliminary order in that case. They are still following 69%. One more state went above this quota of 50%, which is that state? One more state recently went above this quota of 50%. Maharashtra, Maratha quota. Okay. Ninth schedule done. These are the two important cases to remember, mostly IR Coelho case, and stay updated with what's happening on this case, because every now and then hearings keep taking place and things keep changing. 10th schedule, this also we'll discuss in detail, but since we are discussing all the schedules in one go, so this is relating to disqualification on the grounds of defection. 11th schedule, powers of the panchayats, Article 243G, and 12th schedule, Article 243W, relating to powers of municipalities, municipal corporations, municipal committees, etc. Okay, so that's all about all the schedules in one go.